we looked at the actus rea and the mens rea criteria of murder, and we know that to prove any offense, you definitely need three elements: the actus rea and the mens rea and the absence of a valid defense. So actus rea and mens rea as such of murder have been traditionally defined by Sir Edward Coke as a lawful killing of a human being under the principes, which is the modern definition. However, since it has gone through various modern modification, and the simpler version of the definition of murder is that it's a lawful killing of a human being under principes by a human being with malice aforethought. And we looked at the mens rea criteria of malice aforethought, which is either an intention to kill or an intention to cause, GBH. Now today we're going to be focusing on one of the special defenses of murder, and it's diminished responsibility. So we were just going through the basic elemental requirement. If you may remember, the defense of diminished responsibility has certain limbs. If you may check it, so if you look at disability, it has certain limbs. Firstly, there must be a recognized mental or medical condition rather than mental. It's a recognized medical condition which impairs your liability, and as a result, you're now unable to understand the nature of the conduct or form a rational judgment or control yourself. And as a result of this recognized medical condition, impaired liability, and your inability to understand one of the following things, you killed. So that provides an explanation why you murdered someone. Okay, so when we are talking about voluntary manslaughter, you need to understand that murder has taken place. So all the elements of murder are there. In addition, you have a special partial defense. Special partial defense could be diminished responsibility. It could also be loss of control. So these are examinable in your question. Today we'll be focusing on diminished responsibility. First thing that you need to understand is that Section 52 of the Coroners and Justice Act 2009 replicates almost what has been contained previously in Section 2 of the Homicide Act 1957. So diminished responsibility was previously there, where? In Section 2 of the Homicide Act. Currently, it's under Section 52 of the Coroners and Justice Act. Going through the example, so people going through mental difficulties, okay, so people suffering from defect of reason or something shorter than defect of reason, so his reasoning is not right, his forming of ratio is not right, those kind of people, can you categorize them into the original criminals who are like mass killers or serial killers or hired killers? Can you say those two categories are same? People killing under mental depression and people killing for money or for any gang activities or for any criminal activities. They're different kind, right? Therefore, if you had convicted both of these defendants under murder and therefore given them life sentence, would you think the law would have been fair? No. So traditionally, people suffering from defect of reason and some mental abnormality, they pleaded insanity. Okay, but the threshold of insanity is very difficult to prove. So insanity as a defense was very difficult to prove. Something which is shorter than insanity, so defendants in situation where they could not prove insanity, they had to go for, they were given conviction for murder. So it was unfair on their behalf, right? Therefore, the defense of diminished responsibility was developed. So if you read from this paragraph, no, just I'll provide these notes in the photocopy section, so you just follow the lecture, okay? And if you mean in the exam, No, no, no. আচ্ছা, এখন just follow on.
ওগুলো তো লেখা লাগবে যে recognized medical condition.
Yeah, yeah.
To exercise self-control happening, ওগুলো লেখা লাগবে.
Yes. So firstly, you need to understand what sort of defense is diminished responsibility. Is it statutory or common law? It is statutory. Which statute is it? Which statute is it? Coroners and Justice Act. Okay. So the Coroners and Justice Act creates the defense, which is a statutory defense. As I say, there was this problem. So insanity was very difficult to prove, and those defendants who had some mental abnormality, they had tremendous difficulty in proving insanity, and therefore they're going for the full verdict of the murder, right? So the defense of diminished responsibility overcomes the problem by reducing liability from murder to manslaughter. So the diminished responsibility defense was created to overcome this problem. Clear? Now, which section? Yeah, so it was 2(1) of the Homicide Act previously. Now it is Section 52 of the Coroners and Justice Act 2009. As we have seen, we have looked at the elemental requirement. Firstly, what do you need to prove? Abnormality of mental functioning. So you have to prove there is an abnormality of mental functioning. Why is there this abnormality? Because of a recognized medical condition. As a result of that abnormality of mental functioning, your ability is now impaired. So is it only impairment or substantial impairment? It's substantial impairment. So খুব বাজেভাবে আপনার মেন্টাল ফাংশনিংটা নষ্ট হয়ে গেছে। মেন্টাল ফাংশনিংটার কারণে আপনার লায়াবিলিটি যে, ঠিক আছে, আপনার যে একটা বোঝার ক্ষমতা একটা জিনিস, ওই জিনিসটা খুব মোটামুটি সাবস্ট্যান্সিয়ালি কমে গিয়েছে। সো আপনি যেটা abnormality of mental functioning না থাকলে যেভাবে বুঝতেন, ওই abnormality of mental functioning এর কারণে এখন আপনি হয়তো এটা খুব বাজেভাবে বুঝতেছেন না। So you significantly fail to differentiate between what is right and what is wrong, what is rational and what is irrational. And as a result, this provides an explanation. So you killed as a result of your impairment. And what is impaired is given in Section 1A. Second checkpoint. Firstly, there has to be an abnormality of mental functioning. Why? Because of a recognized medical condition. Excellent. And as a result of it, what has happened? There has been a substantial impairment. Of what? Of what is given in Section 1, capital A. Understand nature of conduct, form a rational judgment, or exercise self-control. So you cannot understand what you're doing, the conduct that you're stabbing someone, you're shooting someone, you're throwing someone into fire. You're not understanding what you're doing. What is the nature? You're thinking it might be fun, it might be a game, right? So you do not realize that there might be a death as a result of it. Or you cannot form a rational judgment. So we exemplified this with, so let's say, for example, a husband who has been taking care of a terminally ill wife. So the wife has been going through excruciating pain, and she demands from the husband, kill me, because if you love me, you do not want to see me in such pain, right? So someone who could form a rational judgment would think, no, she's in pain, but if I do this, she'd die. So she'd rather be in pain, and then there might be a cure for it. Okay, so you got emotional by your wife's demand from you that you need to kill her, and you go and kill her because you could not form a rational judgment. So you lost your ratio in deciding, in judgmenting whether or not you should kill a human being, right? And the last one is, although you understand the nature of the conduct, and although you understand or can form a rational judgment, still you cannot control yourself. So this is definitely those kind of scenarios like epilepsy and those medical conditions where there's this tremendous convulsion and you don't have it in your control. Okay, so you lose control, although you realize it's not right, although you realize there might be death resulting from it, but you cannot control it, right? So you cannot exercise self-control. Now, with regards to this part, you need to understand that there is an overlap with another defense. What is it? With regards to the third element, see, there is an overlap. There is an overlap with another defense. What is the defense? Loss of control. See, so if the defendant can prove he could not exercise self-control, can you also not prove there was a loss of control scenario? So there are two defenses, right? One is diminished responsibility. The other is family. The other is loss of control. So when, as a result of diminished responsibility, you're not being able to keep control, then you can also prove loss of control. In your exam, that is diminished responsibility too, but if you can prove the elements of the loss of control defense, you would also get it. Chances are that you would be able to prove, because you are proving your diminished responsibility by saying that you could not exercise self-control. So you can also prove the loss of control defense in this case. Now, this is a very important part. With regards to the burden and standard of proof, you need to understand that in a criminal case, it is always who has the burden of proof? The legal burden?
The legal burden is on the prosecution.
Is on the prosecution. What is the standard? Beyond reasonable doubt. We see that is the general rule. That is the general rule. In general rule, who bears the burden? The prosecution. In exception to the general rule, who would bear the burden? Defendant. So diminished responsibility is one of the defenses, which is an exception to the general rule of burden and standard of proof. So if that is an exception in diminished responsibility, who would have to prove the defense? The defendant. Why? Because in exceptional situation, the legal burden of proof is on the defendant. But there is a difference in standard of proof. When it comes to, yes, good, very good. When it comes to prosecution, the burden is beyond reasonable doubt. When it comes to defendant, the burden is proved if you can prove it. Burden is discharged if you can prove it on the balance of probabilities. So who would prove diminished responsibility? The defendant. On what standard? On balance of probabilities. And once they do it, the prosecution will then have to discharge their burden as well. Okay. Now the ingredients. So if you simplify the ingredient, we know that there is an abnormality of mental functioning from a recognized medical condition, and therefore your liability is impaired and you cannot understand the nature of what you're doing, form a rational judgment, or exercise self-control. And the last bit, point number 3, is the causal link. As a result of your loss of control, failure in understanding the nature, failure in forming a rational judgment, which arose from a recognized medical condition, as a result of which there was an abnormality of mental functioning, right? You killed the victim. Now, we're going to look each of these elements now with cases and whatnot. We go slow here, it gets complicated. Look, previously it was abnormality of mind. So when you say abnormality of mind, you're basically saying you're almost going to the insanity criteria. His mind is abnormal. It has been loosened, it has been relaxed now. It is now abnormality of mental functioning. So although your mind is normal, you could not function well. You get my point? It's a much less stricter test when it comes to the proof of diminished responsibility under the Corners and Justice Act. So there's no abnormality of mind now. It's abnormality of mental functioning, which is easier to prove compared to abnormality of mind. But that would have to be from a recognized medical condition. You won't be able to get the defense, because one of the elemental criteria is that although your mental function is abnormal, it has to be because of a recognized medical condition. Recognized medical condition. Now, it has to fall within. Look, chances are that with the advances in medical science, it is very unlikely that the medical would not be able to recognize if you do have a genuine cause. You get my point? So if you do have a genuine cause, I think you would be able to secure it, because medical science would recognize your mental illness, or medical science would recognize what's wrong, right? Check this bit. So it's World Health Organization or Diagnostic of Statistical Manual of Mental Disorder. So it's WHO or DSM. These are the organization which provides a checklist of what could be recognized medical condition. Very important, understand this part clearly, that it can be physical, psychiatric, psychological.
What's the difference between psychiatric and psychological?
Psychiatry is basically concerned with the fitness of mind. Check. Fitness of mind. So whether you can be medically tested and prove that there was this element in your brain that could not function well. So If you're a psychiatrist, let me just simplify the answer.
There's a difference.
Psychology is based on thoughts. So it's your psychology. So although your mind is functioning well, or you do not have a mental condition, if you're suffering from psychological condition, that is still a recognized medical condition. So psychology has something to do with your thoughts. Your psychology means your thought, right? Psychiatry, when will be tested that you have a recognized psychiatric condition, it is generally with regards to the mind. It is generally with regards to the mind. So whether or not your brain was functioning properly is something that would be looked in psychiatry, right? And whether or not your thoughts were okay would be something that would be looked in psychology.
Psychiatry is a medical condition.
Yeah. So if we could just go to the Bengali words.
Sir, আমার একটা কথা।
Yeah.
Psychological হচ্ছে যে যখন people who gets depressed when trauma দিয়ে যায়, severe trauma, stress দিয়ে
That could still be psychiatric. আচ্ছা বলো question শেষ করেন।
But আপনি তো বললেন যে depression বা shock বা normal panic ওরা মানে they won't satisfy they won't get the defense
Unless and until it's a recognized medical condition.
So don't you think the psychological is a medical psychology দিয়ে, you're playing with someone's psychology, you're making someone depressed. Don't you think it's a recognized medical condition?
That's not medical.
Okay, look.
What about recognized medical condition একটা recognized mental condition?
আচ্ছা আমি বলি দেখেন, psychiatry is often the field of science that deals with the treatment and prevention of mental disorders. So there is some disorder and psychiatry deals with the mental disorder, right? Psychology deals with your thoughts and your functioning of the mind. Do you get my point? It's not a mental disorder. So if you're suffering from a psychological condition, it's not a mental disorder, it's a psychological condition. You can't think properly, or your thoughts are so weird and absurd that you cannot form a rational judgment. Psychiatry has got something to do with mental disorder. And psychological conditions are not necessarily mental disorder, but they had got something to do with the functioning of your mind.
Are they both recognized medical conditions?
Let's put it in this way. Psychiatry is dealing with brain disorders. Psychology is dealing with mind disorders. Do you now understand? So one is inherently biological, the other is inherently thought related. একটা হচ্ছে চিন্তা, মনোবিজ্ঞান, সাইকোলজি, ঠিক আছে? সাইকিয়াট্রি হচ্ছে আপনার যে মেন্টাল ডিসঅর্ডার গুলা, ব্রেইন রিলেটেড ফাংশনিং গুলা দেখবে।
Could you give an example of a psychological
They both
condition?
are
Yeah, very good. So I could give you an example. So think about dementia. In dementia, you think you're possessed by a demon. You think, are you being actually possessed by a demon? So has the demon eaten your brain? You think that you are possessed by a demon. What is that? Psychiatric or psychological?
Isn't it both? A bit of both? No?
The dementia হচ্ছে like I'm police.
Yeah.
Dementia হচ্ছে like brain একটা part নষ্ট হয়ে যাওয়া, you think you're a demon, but you
No, brain একটা part নষ্ট হয়ে যাবে। Your thought is being controlled, that you think you're being possessed by a demon.
But আমি as far as I know যে ব্রেনের একটা নিউরন না কি পার্ট একটা নষ্ট হয়ে গেলে তখন you started thinking that you're possessed by demon, which you're not.
But even that, the brain and part most of it. This is
So
a bit of
really
psychiatric. Yeah,
That's not psychological.
that's my point.
যদি দুইটা recognized medical condition হয়, একটা recognized mental condition আর একটা recognized medical condition.
Okay, let me put it simply. Wait.
একটার মধ্যে না ইংরেজি distinguish করতে বলবে না।
If I may read, look, a psychiatrist is a medical doctor who specializes in preventing, diagnosing, or treating mental illness. So it's mental illness, mental disorder. That's the field of psychiatry. Psychologists are doctors who would be dealing with the study of mind and behavioral disorder. One is mental disorder, which is inherently biological, which is what? Psychiatry. Psychology has something to do, something related to behavioral disorder. So you're behaving like a demon. You get my point? It's not a psychiatric condition. What would be a psychiatric condition? Someone is insane almost. Or someone is going through, someone is schizophrenic, bipolar disorder. These are what? Psychiatric condition. You cannot prevent them. Psychological condition, you prevent with definitely counseling rather than medicines. So but there is this confusion that they are both overlapping fields of
They are
practice.
contradictory.
Not contradictory, they're overlapping. There are some parts which you can deal with psychiatry as well as psychology, but there is still difference. Why? Because psychology is concerned with people's behavior, mind pattern, thinking pattern, and psychiatry is concerned with illness, mental disorder, brain disorders.
It's debatable. মানে দুইটাই আর কি mind related জিনিস।
No, okay.
about this.
No, wait. Let me explain. Check. The physical bit is definitely you are having some physical disorders, right? Psychiatric and psychological are overlapping field of practice or profession, but there are still differences. Get this point right. Psychology deals with people's behavior and mind and thoughts. Psychology.
No, I get that.
And psychiatry deals with mental diseases, mental illness. It's not behavioral problems or patterns that are being dealt with in
This
psychiatry.
thing that I'm possessed by a demon, this thing, like, isn't that a kind of an illness?
No, it's not.
No?
No, it's a psychological medical condition that you think that there's a demon. Can you medically test a demon?
No.
That is the field of psychiatry. If you could have tested it through medical procedures that there is this demon, you're positively demonized, then that is like a psychiatric condition, which you can with many diseases. But when it comes to like dementia, you're thinking that you're being possessed by a demon. The demon is not there in the mind. It has not infected or corrupted or diseased your brain. You get my point? So psychiatry is dealing with brain, psychology is dealing with mind. That's the simplest of definition or differential definition you can get. One is related to brain, the other is related to mind and your thoughts.
It's actually debatable.
It is, yes. So,
মানে physical and psychiatry হচ্ছে মানে almost same.
no. Physical is definitely something to do with your physique.
মানে
Physique.
physical হচ্ছে তো মানে doctors are gonna prescribe.
Just get this word right. Physical is with your body, psychiatric is with your brain, psychological is your mind and behavior. Clear? That's it. The recognized medical condition include both functional and organic medical condition. What this means is that, so recognized psychosis including schizophrenia, which are medical tests, mood disorders, mania, and depression and neurosis such as phobias, post-traumatic stress disorder, conditions like dementia and epilepsy might form the basis of the plea of diminished responsibility. Obviously, you can see that schizophrenia, mood disorders, these are something that can be tested medically, right? Through the field of psychiatry. Whereas conditions such as dementia is something that is a field of psychology, right? So if you're possessed by a demon, you'd rather go to a psychologist and not a psychiatrist.
Epilepsy is a recognized medical condition.
It is physical.
Yeah,
So it says,
why psychological?
no, it's not psychological. I'm just picking up. This one is psychological. These things are be psychiatric. This thing is physical,
Okay.
right?
No, epilepsy হচ্ছে কিছু
So general normal depression and jealousy are not recognized medical condition.
jealousy তো Othello syndrome.
But this is not psychological.
Wait,
Othello syndrome though is like psychological. No, psychological, no, actually. psychiatric also.
But check this out: morbid or pathological jealousy, they are recognized medically. So acute forms of jealousy, so which can be tested medically. So that's almost like a psychological condition as well. So there can be no one who could not make you feel jealous. You would get jealous and you'd be going insane almost in jealousy. That's like a morbid or pathological jealousy. You get my point? So normal depression, normal jealousy, they do not count as recognized medical condition. Pathological or morbid, deadly jealous person may.
Or with deals with emotional stuff, like you get jealous.
Normal jealousy,
But it's not even normal jealousy.
pathological jealousy,
Yeah.
which can be laboratory tested. Yes, then that can form the basis of recognized medical condition. So recognized medical condition, it's not a mental condition, okay? If it was abnormality of mind, which was previously, we would be just dealing with psychiatric field. But since it's an abnormal, sorry,
This is physical.
which one?
You said recognized medical condition.
Can be physical, can be psychiatric, can be
No,
psychological.
the pathological.
No, that's clearly psychological. Pathological jealousy.
Extreme
But
jealousy.
it could be tested.
Sorry?
But it could be tested, right?
Tested in terms of medical science, but you wouldn't be getting a degree. Look, your jealousy is up to that level. It's not a disease, it's a behavioral pattern. So his behavior or her behavior is that he or she is morbidly jealous.
Extreme jealousy.
Yeah.
So it is an anomalous total syndrome. Ours is vinaigrette cases and open eye.
Next point, check. So medical evidence.
Yeah.
There would have to be medical evidence, right? So it has to be medically tested. So it's a recognized medical condition. Do we agree on that point? Now, if it is a recognized medical condition, are we ultimately leaving the availability of the defense to medical expert or the jury?
Medical expert.
No, it's the jury. Let me explain why. So our jury is entitled to reject even, or the availability of the defense is for the jury. Why? Look at the elements of the defense. It's abnormality of
Mental functioning.
recognized substantial impairment, and you cannot understand the nature of your conduct, right? Would the defense totally rest upon this limb? Or is it just one of the conditions? Recognized medical condition, is it just one of the condition, or does it define or complete the entire defense?
No, that's just one of them.
That's just one of the requirement of proving diminished responsibility. So who check these? Abnormality of mental functioning, nature of the conduct, rational judgment. These would ultimately be decided by the jury and not the medical expert. So the medical expert comes into play when it comes to only recognized medical condition. Even after having a recognized medical condition, you can think properly, and the jury thinks you can form rational judgment, and the jury thinks you are not suffering from an abnormality of mental functioning. He would not be giving you the defense. So ultimately, whether or not you get the defense is a question of fact. For whom to decide, expert or jury? Jury to decide.
But don't you think when the medical expert, when the medical expert is going to explain to jury is going to be giving decisions on the basis of the medical expert, what is the medical expert saying, right?
So don't you also think that there would be prosecution lawyer trying to undermine what the medical expert is saying? So the prosecution lawyer would be there to prove that although there was a recognized medical condition, defendants still retain the capacity to think rationally, or to form a rational judgment, or to exercise self-control. So these questions, whether or not the defendant understood the nature, whether or not there was a rational judgment, these questions would still need to be decided by the jury. And therefore, ultimately, whether or not you get the defense of diminished responsibility is a question of fact for the jury to decide.
But don't you think the jury is going to listen to what the medical expert is saying?
Without
They're going to listen to it,
prosecution,
but that's not the only proof. You still have to prove that abnormality of mental functioning and the loss of control. And
medical condition, medical expert যেটা বলছে ওটা ফেভারই তো যাবে তাই না jury?
Well, this is a field of academic debate. So it has always been stated that whenever there is a medical expert coming into the trial, juries are inherently biased towards their opinion. So if a medical expert says something, it is unlikely that the jury would say something else. But when it comes to diminished responsibility, it's just one of the requirements, and there are loads of other requirements as well, which the prosecution would have to prove. And who would the prosecution convince? It's the jury and not the medical expert. You get my point? So ultimately, whether or not you get the defense is a question of fact for the jury to decide. This is an easy requirement. Abnormality of mental functioning must be substantially impaired. So খুব বাজেভাবে আপনার behavioral aspects গুলা impacted হতে হবে, so that you do not understand one, the nature of your conduct, to form rational judgment or exercise self-control. So even if you retain some degree of self-control or a significant extent of self-control, you're not getting the defense. Why? Because your ability to do one of these things was not substantially impaired. So আপনার যদি কিছুটা কন্ট্রোল থেকে যায়, judgment form করার, nature understand করার, অথবা self-control exercise করার, you would still not be able to get the defense. So the impairment would need to be substantial. Now, when it comes to not understanding the nature of the conduct, it was famously said that it's almost like a borderline insanity. So it's like an insane person. It's like an insane person, but not an insane person. So if you would prove that he was insane, that's a higher degree of proof than diminished responsibility. You'd therefore be going for insanity. Now, get this point right. When you prove insanity and when you prove diminished responsibility, what is the difference?
Sanity is insane person, a mad person.
No, what is the difference with regards to verdict?
When you're giving a tag to someone that you're insane, and then
No, what is the verdict of the jury?
They will send the insane person to the medical
to the mental
hospital.
asylum.
Yeah. And
That's the consequence. Okay, you're not understanding the question. Let me explain it. So the verdict is either guilty or not guilty. When it comes to insanity, are you guilty or not guilty?
Not guilty.
Not guilty by reason of insanity, and therefore you're being sent to the mental hospital. If you get diminished responsibility, are you still guilty of what? Voluntary manslaughter. So you're not acquitted. You're not acquitted. Okay, so it's not guilty of murder but guilty of manslaughter. So the jury will be saying guilty of manslaughter by reason of diminished responsibility. And if you prove insanity, however, you're not guilty. You're getting fully acquitted but being sent to the mental hospital. So you're not guilty by reason of insanity. And here you're guilty of manslaughter by reason of diminished responsibility. So obviously, someone who tried to prove he's insane would have to go to the next level. So diminished responsibility is anything which is below insanity. So it's borderline insanity, as a result of which you're failing to understand the nature of your conduct. You're not insane, but it's borderline. It's there. It's almost there. That's why you cannot understand what you do. When it comes to forming rational judgment, read these parts. First scenario. We'll have a proof for the contract as well. So just let's quickly go through. Just read this. Read 3 of this. First thing, the woman is suffering from what? PTSD, post-traumatic stress disorder. Why? Because she was beaten by her husband. So do you think the husband has committed something which is not right? Yeah. The woman thinks that as well. So she thinks husband has done something which is not right. Would you or you kill that husband?
No.
He has done something which is not right, but would you take law in your hand?
If I was at your place, then I would have.
Then you'd be getting the defense of diminished responsibility because you are not being able to form a rational judgment. So let's think I took your mobile phone. So I did something wrong. Would you kill me? Why? Because that's your ratio. It's a rational judgment not to kill me. So I had, like, let's say for example I have punched you. You might kill me, but is it rational to kill me?
No.
Can killing be rationalized in any case? No.
You punch me, I will punch you back.
Yeah.
But I won't kill you.
But if I kill you, you can't kill me back because you're already dead.
Yeah.
Right. No, so if I do something which is like very heinous, I beat you, I take your mobile phone, would you still kill me? Can you ever rationalize killing? No. Killing is like the last step, right? So when you try to kill someone, you're definitely not being able to form a rational judgment. Look what the woman thinks. She thinks that only burning her husband to death will get rid of the world of his sins. Yeah. So she burnt him alive to get rid of his sins. That's not a rational judgment, is it? No. Check the last point. So here is a depressed man who is taking care of terminally ill spouse, kills her. Why? She requested, kill me. And he thought, last line, I felt I would never think straight again until I had given her what she wanted. So he thought she wanted to die and I can't be relaxed or relieved, or I can't think again if I don't give her what she wanted. So what did she want? To get killed. But giving her what she wanted, is it a rational judgment? No.
But don't you think here consensual conduct?
Consent is irrelevant when it comes to murder. Euthanasia is not allowed. This is easy, it's self-explanatory. As a result of all the above criteria that we have studied before, you killed. So you would not have killed if there was not a recognized medical condition. You would not have killed if there was not abnormality of mental functioning. And you would not have killed if your ability or liability was substantially impaired. To understand the nature, to form a rational judgment, or to exercise self-control. These are essay question angle. Just go home and read this, the relationship with insanity. It's in the subject guide. Today we'll be just focusing a little on alcohol, drugs, and diminished responsibility check. For the purpose of an act, a state of intoxication is not an abnormality of mental functioning arising from a recognized medical condition. So if you're being intoxicated and therefore you cannot think properly, your loss of thinking capacity, is it arising from that drug abuse or is it from a recognized medical condition? It's from the drug abuse. And what does this act say? It has to be from a recognized medical condition. So if you're intoxicated, you're not getting the defense of diminished responsibility. You can rather claim intoxication. Yeah, so that's a part of studying the defense of intoxication and not relevant to the study of diminished responsibility. Diminished responsibility has to be a recognized medical condition. Where there are two causes of abnormality of mind, one which is within the scope of the defense, which is what? Recognized medical condition, and the other which is not, defendant may nonetheless succeed in the defense even if he would not or may not have killed if he had been sober. So check. একটু আগে যেটা বলছিলাম সেটা হচ্ছে ওর যে মেন্টাল ফাংশনটা নষ্ট হয়েছে was the result of a drug effect. এখন যেটা বলতেছে সেটা হচ্ছে ওর অলরেডি তার recognized medical condition আছে, এর উপরে আবার on top of that he takes alcohol or any other thing. In that case, he may still succeed because there is this scope that he could have proved it, the diminished responsibility. Without that,
That's an external element.
that is yes.
So,
But he already had a recognized medical condition.
but it's not because of that. It's because of what he took.
No, it's because of both. It's because of a combination of alcohol and his recognized medical
But
condition.
not solely the
Alcohol, no. If it's solely the alcohol, then he can't.
And half self-induced.
Yeah, then he still might be able to succeed. So with regards to alcohol and drugs, what you need to know is that if your mental functioning is disrupted as a result of only alcohol or drugs, you're not getting difference. It's half alcohol and half your mental functioning arising from recognized medical condition, you still may be able to get the difference. However, in the recent case, check, it was held that defendant's abnormality, which is an organic brain injury, he had an abnormality of mental functioning, but it was significantly impaired as a result of alcohol, and therefore the defense was not available. So had he not taken alcohol, he could have retained control. Since he took alcohol, it got significantly impaired. এই জায়গায় ডিফারেন্স দেওয়া হয়নি। সো ফার্স্টে বলবেন শুধু অ্যালকোহলের জন্য পাবে না, তারপর বলবেন যে অ্যালকোহল প্লাস যদি ডিমিনিশড থাকে পেতেও পারে, লাস্টে আবার বলবেন যে হিলে এরকম একটা সিনারিওতে 2008 এ রিসেন্টলি দেয়নি।
the just alcohol.
This one is both. He had an injury, but impairment যেটা হয়েছে ওটা impaired হয়েছে আসলে অ্যালকোহলের জন্য, তখন তাকে ডিফেন্সটা দেওয়া হয়নি। But you need to realize that alcohol abuse, drug abuse, এগুলা কিন্তু normal conditions, they are not recognized medical condition এর জন্য পাচ্ছে না, but there are some alcohol conditions which are like recognized medical condition, alcohol dependency syndrome, যে আপনি অ্যালকোহল ছাড়া চলতেই পারছেন না। এই যে অ্যালকোহল যে খাচ্ছেন, এই যে একটা ভলান্টারি না, আপনি ইচ্ছে করে খাচ্ছেন না, ইনভলান্টারি অটোমেটিক আপনি অ্যালকোহল খেয়ে ফেলছেন। This is what alcohol dependency syndrome.
So don't you think
Yeah,
it's
addicted to
automatic?
it.
When the victim is the defendant is automated.
Which automatism? Sane automatism or insane automatism?
It is the same automatic.
Sane automatism. But he's not just taking it for fun. It might be automatism. We're not studying that today. It might be yes. So let's not go there. It's another defense. Total অন্যরকম requirement না পুরা যে yes, external element quick tweak হতে পারে। We're not talking about that. We're talking about that condition where taking of the alcohol is not voluntary. It's like almost involuntary. You're dependent on alcohol. You cannot live without alcohol. It is a recognized medical condition. বলছে।
It's not fault, right?
How is it fault? It's a condition.
Sir, involuntary, sir, এখানে involuntary voluntary নিয়ে একটা question আছে, like আপনি জানেন যে আপনি অ্যালকোহলটা কনজিউম করতেছেন, তাই না? Don't you think it's voluntary? আপনি তো কারো কথা খাচ্ছেন না।
কোনটা?
You're intaking alcohol.
Dependency syndrome. Okay, check. হ্যাঁ, আপনাদের কথা যুক্তি আছে। It does not necessarily flow from the fact that defendant suffered from alcohol dependency syndrome, that he has established necessarily abnormality of mental functioning. Well, even if there is alcohol dependency syndrome, it's just a recognized medical condition. ওটা থেকে কিন্তু বাকি সবকিছু প্রুভ হতে হবে তখন। Abnormality of mental functioning, substantial impairment, unable to form, সবগুলো যদি প্রুভ করতে পারেন, বলছে যে ADS is just a recognized medical condition. এটার পর তো আরো অন্যান্য রিকোয়ারমেন্ট গুলো আছে যেগুলো you'd have to satisfy the jury with, তাই না? সেগুলো যদি পারেন তাহলে হয়ে যাবে। Just because there is this alcohol dependency does not on itself mean that you're getting defense. This is just a recognized medical condition, as a result of which there is an abnormal mental functioning and the other elements are grouped, then you can prove the also. Yeah,
এটা কি recognized mental নাকি medical?
it's a medical condition, recognized medical condition. Okay, so we finished by asking some couple of quick questions. Where was diminished responsibility previously? Section 2 of Homicide Act. Where is it now? 52 of Coronation Justice Act. Why did we develop this defense? So that যে positions গুলা insanity দিয়ে cover করা যাচ্ছিল না, ইনসানিটি টেস্ট প্রুফ করতে পারছিলেন না, ওই সিচুয়েশনে আপনি ডিফেন্ডেন্টকে একটা রেমেডি দিতে পারছিলেন। ইফ ইউ গেট diminished responsibility, are you convicted of murder?
No, you're
What are you convicted of?
Voluntary manslaughter.
Of voluntary manslaughter. So is it a full defense? It's a partial defense. Does it apply to OAPA?
No.
It applies only to
Voluntary
murder.
manslaughter.
Does it apply to gross negligent manslaughter, constructive manslaughter? No, this is a special defense, applies only to murder. So diminished responsibility, loss of control are special defenses in a sense that they apply only to murder, and partial defenses, partial in a sense that you're not getting full acquittal.
Partial.
Yes. So what are the requirements again if we revise? Firstly, there would have to be an
Abnormality of mental functioning.
there would have to be an abnormality of mental functioning. As a result of what?
It does not understand the nature of these.
No, as a result of what? Recognize
Recognize
medical condition. Because of that medical condition and abnormality of mental functioning, what has been impaired? It has, something has been substantially impaired. So that something is given in capital 1A. Three things. What are they?
Losses control,
No.
self-control,
No,
To understand the nature of the conduct,
to form a rational judgment,
to form a rational judgment, or to
to
exercise self-control. And as a result of all of this, there is an explanation why you killed. That's it. We'll be starting the contract class just about in 5 minutes. So we finished our diminished responsibility lecture here.